let's dive right in. So I'm real excited today to have, let's see here, Michael Ward, uh, partner from Morrison Foerster, and Anna Yuan, OF Counsel, with us today. Together, Mike and Anna will lead this session, IP 101, Introduction to Intellectual Property, and it's a practical deep dive that's tailored just for you and your Farm Robotics Challenge teams on building robust IP portfolios for ag tech and AI-driven robotics with those best practices for protecting your data, your algorithms, and machine learning models in today's rapidly evolving field and environment. So a little bit about Morrison Foerster. They are our exclusive law firm partner for this year's challenge, and they're really providing teams and you guys with tremendous value. So in addition to courses like this, of which they will have another one in the spring, they're also offering teams free confidential office hours to directly answer any legal questions and provide guidance to those teams that are pursuing commercialization. So I think this extremely valuable opportunity for you all if you want to pursue that. And then Morrison Foerster, the firm, is a leading global law firm. They have clients, including some of the most innovative companies, from startups to Fortune 100 enterprises. I would say Morrison Foerster is the firm for food and agriculture. They represent many different stakeholders, from scientists in labs, to farmers nurturing crops, to ag tech pioneers revolutionizing farming technology, which is what you are all involved in, and also consumer companies and many global brands that you would recognize that save or that sell your favorite food. So you can learn more about them on their website. It's really simple, mofo.com, mofo.com. And with that, I think I will hand it over to Mike and Anna to take the microphone and run the session. So yeah, thank you both for being here today.
Great. Thanks, Kelly, for the introduction. Welcome, everybody. As Kelly said, my name is Mike Ward, and Anna Yuan and I are going to give you a short presentation today on sort of an IP and IP 101 as it relates to robotics. We want to make sure today that we get your questions answered. So we have enabled the chat function today in the Zoom, and feel free to put your questions in there. No question is too silly, or if you don't understand something, please ask. We're happy to answer your questions. And as Kelly said, we also offer free office hours if you have something confidential that you want to talk to us about your specific project and how you should go about protecting it. We're happy to talk to you about that. And you can get our contact information from Kelly in order to reach out to us. So with that, let's turn to the first slide after this, Anna. Here's our agenda for today. We're going to talk first. We want to kind of level set with just basically the basics so that everyone understands IP, and then we can turn to some of the AI and robotics issues at the end. But we're going to talk about trade secrets and patents, who should be named in an inventor and why that matters, assignments, what's an assignment, what does licensing mean, and then the quick comment on the patent application process, and then we'll turn to AI and robotics. So, why IP? Why do we set aside an entire hour and a half for you guys to hear about IP? Well, IP matters. There was a survey done some years ago of Fortune 500 companies that estimated that from 45 to 75% of the wealth of those companies, excuse me, comes from their IP rights. Next slide, Anna. So here's the world of IP. This is it. Copyrights, which include, excuse me, photographs, software, web pages, data pages. If you take a picture on your cell phone, you own the copyright associated with that picture. Trade secrets, those cover secret inventions and methods, customer lists, tools, those sorts of things. And then there are patents. And there are ways that you can protect plants through plant variety protection and plant breeders' rights. And finally, trademarks. Trademarks, the most first question for the day is what's the most famous trademark in the world these days? Can anyone know? Anybody know? No answers? Apple, there you go. Luca, very good. It is. It's the most famous trademark in the world, most recognizable, and it's the strongest, one of the strongest marks in the world. So, trademarks and IP are all around us all the time. And this world that we just showed you, these are the buckets of the types of intellectual property. So, let's now turn to patents. First, we'll do a little bit about trade secrets. So, what is a trade secret? Trade secret includes a formula, a pattern, some program, a device, a method, or a process. But the most important thing about a trade secret is it derives its economic value from not being generally known to the public. So if it's not generally known to the public, well, back, it's a subject of efforts that are reasonable under the circumstances to maintain its secrecy. So you have to, it derives its value from being secret, and you have to take reasonable steps to keep it secret. Okay? So, next slide, next question. Excuse me. What's the most famous trade secret of all? Luca got Apple last time. Does anyone else know the answer to this one? Coke. Absolutely. Next slide. The Coca-Cola formula. The Coca-Cola formula is the most famous trade secret. Years and years ago, Coca-Cola made a decision. They came up with a new formula for their new drink, and they decided they were going to keep it as a trade secret rather than get a patent on it. Had they got a patent on that formula, it would have lasted 20 years, and they would have had to teach everybody what that formula was. But it's been kept as a trade secret since it was invented a very, very long time ago. And they've done a really good job of it. If you go down to their headquarters in Atlanta, they have a safe where the formula for the Coca-Cola is still kept and kept secret. So next slide, Anna. So trade secrets and patents. If they both protect new software, new methods of synthesis, new formulations, how do you know when to protect it as a trade secret? And how do you know when to protect it as a patent? So next slide. These are some of the considerations when thinking about protecting whether you want to protect it as a trade secret or as a patent. If that invention cannot be easily discovered, that is, you send the product out into the market and no one's going to be able to reverse engineer it, well, something like the Coke formula where they couldn't figure it out, then that's something you may want to think about keeping as a trade secret. If that invention is simply not patentable, all right, that's something you may want to think about as a trade secret. The beauty of a trade secret is if you do protect it as a trade secret and you're successful at doing so, the term will last forever. In contrast with a patent, patents only last for 20 years from the patent filing. And you're going to need to get a patent if that invention can be discovered or reverse engineered. If somebody can reverse engineer what you've put out there, then you're going to have to patent it because there's no trade secret in something that can be figured out. So how do you protect trade secrets? Next slide, Anna. First, you can't disclose it publicly. You're going to need confidentiality agreements with all your employees and any consultants that you might be working with. You need appropriate firewalls and email security, and you need to make sure you're encrypting your communications. The most important thing to remember when protecting a trade secret is that you need to act reasonably. So what is reasonable? Well, you think about technology, it's constantly improving. You think about a phone, a cell phone years ago, 4 or 5 years ago, very few people had facial recognition on their cell phones, okay? Back then, it wasn't really reasonable to have facial recognition because it really wasn't available. It wasn't much an easy thing to get access to. Today, if you don't have facial recognition on your cell phone, that's not acting reasonably when it comes to protecting trade secrets. So it's a moving target. It's important to be acting reasonably at the time. So next slide. So what are patents? Patents protect inventions. They are country by country. If one thing you learn from today's presentation, it's important to know that there's no such thing as a worldwide patent. I'll hear entrepreneurs, I'm based out here in San Francisco, we're in Silicon Valley many times, and you'll hear entrepreneurs from the Silicon Valley who'll say, I have a worldwide patent on my invention. Those things do not exist, all right? You may have a worldwide patent application, a PCT application that'll have a WO on it when it's published. But that is not a patent. That's a patent application, which will lead to a patent in a particular country. It's country by country. And patents are a governmental grant of rights to exclude others for a period of years. What does that mean? Well, that's what we're going to explain. Next slide. All right. So we had Abhi who got Coke, and we had Luca who got Apple. Now, what is the most famous invention in history? Any guesses? Any suggestions? Anybody? Steam engine. Good. It's a good suggestion. Anything else? Light bulb. That's a good one. Any others? TV. All right. Next slide, Anna. One of the things when you get to be an instructor, you get to choose what is the most famous invention in history. And our position here today is the most famous invention in history is the glazed donut. All right. So now we have a patent on this glazed donut. Let's go to the next slide, Anna. All right. I was the inventor of the glazed donut, as it turns out, and I have a patent on my glazed donut. And my question for all of you is, can I sell my glazed donut? Right? I filed my patent application. The patent office says, oh, this is a new invention. They're giving me a patent. Can I sell? What do you guys think? Yes? No? Maybe? We got a couple of yeses? Lots of yeses? Yes? Yes? Lots of yes. Everyone seems to think yes. Well, you're going to get a lawyer's answer. Anytime you talk to a lawyer, most of the time they will say, next slide, it depends. All right? So what's it going to depend on? All right, next slide, Anna. Well, it turns out that while I was the inventor of the glazed donut, I was not the inventor of the donut. And as it turns out, Mr. Donut, who invented the donut there on the left, got a patent that covered all donuts. I came along and invented the glazed donut. Okay, so in our example here, what I'm illustrating is the difference between patentability versus infringement. When I look back on my career, this question, patentability versus infringement, is by far the most confusing thing and the most questions I receive in my career all around this particular topic. First question, patentability. Patentability means on that donut on the left, that was an old donut, and then I came along and invented a new donut. Am I entitled to a new patent? That's the question of patentability, all right? Once I got my new patent for that donut on the right, the question is whether somebody is selling a donut that is covered by my patent. That's a question of infringement. So in my example here, the patentability issue is whether or not I can get a patent on the glazed donut. The infringement issue is while I have a patent on my glazed donut, Mr. Donut has a patent that covers all donuts, including glazed donuts. And because of that, I have an infringement problem. All right? So next slide. So patents do not give an inventor the right to sell. All right, that was the question I asked. Can I sell my donut? Patents don't give you the right to sell. Patents are an exclusionary right. What does that mean? Patents give you the right to exclude others from making, using, selling, importing, and offering for sale the claimed invention. So you might have a patent on your invention. You may invented a great robotic device that's going to work on a tractor. It's a fantastic thing. You may have a patent on that, and people said this is a great invention. But you always have to answer the question: does someone else have a broader, more dominant patent? Do you have what is known as a freedom to operate problem? That is, somebody else has a broader patent. Okay? So that is the question and the differences between patentability and infringement. So that you may develop the greatest new invention, but it's possible that other people may have patents that cover what you're doing or aspects of what you're doing, and that prevents you from selling your device. All right? So just because you have a patent does not mean you can sell your invention. Okay? It's a really important concept. Next slide. This is a list of the types of patents that are out there. There are utility, and those are the most common ones. All right, we have a question before we move on, Anna, here. It says, can the glazed donut be patented after the old donut patent expires? And the answer is yes, absolutely it can. There's um, no relation between whether a patent is still pending and or it's expired and whether or not you can get a new patent later on something else. That new patent application will be examined based on the prior art, including that patent and anything else that's in the prior art. So the other type of patents I want to highlight here is design patents. So design patents, we represented Apple when Apple fought Samsung over the iPhone. And there was a huge patent infringement case. And one of the most valuable patents in that patent infringement case was a design patent that showed a shape of the iPhone. That turned out to be the patent that went up to the Supreme Court twice. And ultimately, Apple received a little over $500 million from Samsung because of infringement of a design patent. And then there are plant patents that cover plants that reproduce asexually. So utility, design, and plant. Next slide, Anna. So I want to talk a little bit about inventorship. Next slide. Like who should be named as an inventorship? Many of you are graduate students or students who are in a situation where people are writing scientific papers. It's important to understand that papers that get published is authorship. Authorship will list the authors of that particular paper. Authorship and inventorship are completely different things. Inventorship requires a legal analysis of the patent claims and the related facts. All right? In authorship, many times in the medical community, for example, you will see authors will be, as long as an abstract in terms of people that they're listing. They list people who worked on it, people who brought in the grant money. There are many, many authors that can get named. Not so with patents. You have to contribute to at least one claim. So next slide, Anna. What does contribute mean? So contribution or contributing to a claim means more than suggesting the desired result. So a professor who sits back and says to the student, go do this. I think this will work. That is not contribution. All right. That professor needs to be suggesting more than simply the end result that he or she seeks. All right. It can't be more, can't be just experimentation. It can't be somebody that is doing a test and coming back to you with the results. All right. And merely reducing the invention to practice, that's not enough either. It has to be a significant contribution in order to be named as an inventor. Next slide. So when you have two or more inventors working together, there has to be some collaboration or connection between the inventors. They don't have to work in the same place. They don't have to work at the same time. One person can work on it and hand it off to the another, but there has to be some connection in order for there to be two joint inventors. And somebody may contribute just a little, and somebody may contribute a lot, and they can still be joint inventors. So why does this all matter? Why do we spend a little bit of time on these talks to talk about inventorship? Next slide. Inventorship equals ownership. Next slide, Anna. All right. Each inventor, if you're named as an inventor, you own an equal and undivided interest in that patent application. All right. As an inventor, you must sign a declaration that states you're an inventor, and then you assign your rights to a company or a university. Many of you may be working for a university. When you start to work for a university, you are required to sign an agreement that says anything I invent while working here at the university, I will assign my rights to that university. Okay, so if you're named as an inventor, you're under an obligation to assign your rights to the university. If you're an undergraduate student or a high school student, you don't have such obligations. You would own whatever you've invented. Okay, once those rights are transferred, they can be licensed. Next slide. These are just some of the licensing options that you might, take. So the patent has been assigned to the university. The university may give an exclusive or a non-exclusive license. That means they might give all the rights to somebody or just some of the rights. They might give rights in certain areas. They might give sub-license rights and on and on. So next slide, Anna. So what's required to obtain a patent? Next slide. So what must you show? First, you must show that it's patent eligible, that the subject matter is, and Anna's going to talk about more of this when she talks about software. But there are certain things that are simply not eligible to be patented. Anna will talk about that. It has to be new. It has to be non-obvious. And obviousness is a sort of a legal term. It's what we call the Lawyers Full Employment Act in terms of how to prove something is non-obvious over what's been done before. And then it also must meet the written description and enablement requirements. And this means that you must describe your invention in sufficient detail. Next slide, Anna. All right. This is a typical patent application sort of filing strategy. Typically, in the US, one would first file what's known as a provisional patent application. Provisional patent applications are not examined by the patent office. They're a way by which you can file an application and then wait another year before you file what's known as a non-provisional application. Oftentimes, it's an international application that could be filed around the world, or it could be just a US only application. And that international application would then proceed to that yellow block below where it's the national stage applications. You may choose that you want to file that thing in Europe, in Mexico, in the US, and Canada, and that's when that would take place. And then they all proceed on to an issued patent. So this is the typical patent filing strategy. Next slide. All right. So that's the introduction to intellectual property. So you now have the basics of IP 101, and we're going to turn to Anna's portion of the talk where she's going to go into a much deeper dive on strategies for AI, robotics, and ag tech. And feel free to put your questions in the chat as we proceed. Anna?
Thanks, Mike. Hi, everyone. By way of introduction, my name is Anna Yuan. I am an of counsel based in the Bay Area, and my practice primarily focuses on formulating IP strategies and managing and developing patent portfolios. I work with companies of all sizes. I've worked with a lot of startups to help them draft their first patent application and really build their IP strategies. And I also, on the other side of the spectrum, work with multinational companies to help manage their global patent portfolios. And just really quickly, in terms of my technical background, I studied computer engineering and electrical engineering in college with minors in mathematics and computer science. And after college, I worked at Microsoft for a couple of years as a PM, and then went to law school in Boston. And I've been working at MoFo ever since I graduated. So it's been 11 years. And now most of my practice is actually with AI companies, ag tech companies, and robotics companies. So, one of the most asked questions from my early stage companies and early stage clients is how should I think about my IP strategies? When should I consider filing a patent application and why? And what I tell them is the number one reason that you should consider filing patent applications is for fundraising. As a startup, you may think, oh, I want to get patents so that I can potentially sue my competitors that are in the same space. And I tell them, no, IP litigation is really expensive, and a lot of times it's a zero-sum game. And so, as an early stage company with limited resources, it's not a good reason to get patents in order to sue your competitors. The biggest reason is really fundraising. And what I mean by that is when you talk to your investors and you tell them how great your technology is and how it's going to really dominate the market and make your investors a lot of money, what you are saying as your core technology needs to be reflected in your patent filings. It's generally a red flag for investors, and we represent a lot of really big investors to vet early stage companies. A big red flag for investors is when you say, what your core technology is, and you don't have a patent filing on that. So another big reason for filing patent applications is it provides defense against competitors. So I just said, you probably don't want to get patents to sue others, but on the other side, you can't really prevent your competitors from potentially threatening IP litigation against you, especially as you become, a really big major player in the market. You're probably going to receive various threats from your competitors. And those threats can come in the form of a cease and desist letter, where the competitor is going to say, hey, here is a list of our patents that you are infringing by making and selling your products, which can be, software, robotics, whatever, and you need to stop now, right? And so we work with a lot of clients who come to us with those type of letters. And when we get those letters and we need to advise them how best to respond, the first question we ask is, do you have patents that are relevant to your competitors, right? If you do have those patents that you can potentially assert against your competitors, then you have a lot of bargaining chip in this negotiation, right? So you can write back to them and say, first of all, I don't infringe any of your patents. And also here's a list of my patents that you are infringing, right? So it really becomes a negotiation. And sometimes the parties decide to walk away, or they can potentially reach a cross-license deal. But the worst situation is you get a cease and desist letter, sometimes from a multinational company, and you don't have any patent assets, right? That means you have no bargaining chips in this conversation. So that is another big reason that you may want to file patent applications. As Mike mentioned, patent applications or patents provide protection against reverse engineering. So, if once you release your products, people may want to reverse engineer your product. And maybe some people even came up with it independently without looking at your products. It doesn't matter. If you have a patent that covers your invention, then you can go after people who reverse engineer your products or people who independently came up with the same idea. It does not matter, right? In comparison, trade secret doesn't provide this level of protection. You may be doing this in secret, right? And you think you're secure because it's kept as a trade secret, but you can't really do anything when somebody independently came up with the idea or reverse engineer your invention. And so really, I do want to say trade secret is a very valuable form of IP. For example, it can be relatively cheaper, right? You don't have to file anything with the government. You just need to keep something secret. So it is a really valuable form of IP. But really, you want to think about the deficiencies of trade secret, and that can kind of help you inform where you should file patent applications. The first in terms of the deficiencies of trade secret, the first consideration is whether your invention can even be kept as a trade secret, right? So a lot of my clients, they have developed robotics and that are shipped to businesses and users. They may have developed software packages that have graphical user interfaces, right? So those things are inherently public, and you literally cannot keep them as trade secret, right? And so to the extent that you want to protect, various hardware components, how you assemble them together, those need to be protected via patent filings. They cannot be kept as secret. Another example is your software may provide unique workflows and user scenarios. And to the extent that those are valuable, again, they cannot be kept secret. So you have to file a patent application if you want to protect them. Enforceability is also a big issue with trade secret. As you all probably know, people move around between companies all the time, sometimes between competitors. And so trade secret can oftentimes be impractical to enforce. And so again, if you have something that's really core to your technology, you may want to have some level of patent protection so that you're not completely exposed when a employee leaves and takes the secret with them and use them inappropriately. And as I mentioned before, trade secret cannot protect against independent development or reverse engineering. So all of this really comes back to fundraising, right? Investors know what the deficiencies of trade secrets are. They know the advantages of patent. So, all of this is to say, it's a red flag if you say, oh, I have all these great technologies that's going to set me apart, but I don't have any patent filings on these things. And this varies from client to client, but generally, for technology companies, a hybrid approach is what's most appropriate, meaning that we'll look at your product, we'll look at your platform, and both on the hardware side and on the software side, and we're going to figure out what aspects of that product or platform should be protected in a patent filing or multiple patent filings, right? Where we can really protect like the high level things that can give you really broad protection. And then we're going to identify the things that are really under the hood that you can reasonably keep as trade secret. So this way you're going to have a hybrid IP approach with some patents and some trade secret. And usually that is the sort of thing that investors like to hear, that you can articulate a very sophisticated IP strategy. So just really quickly, as you may have imagined, the number of AI-related patent filings has skyrocketed at about 10 years ago, and it's just been going up exponentially year after year. And in terms of jurisdictions, as you can see on the map, it's kind of the usual suspects, right? But I would just say that it is a decision that you want to go over with your patent attorney. You probably don't want to file in a lot of countries because it can get expensive. And so it's going to come down to where you're going to be operating, where you may be engaging manufacturers or third-party partners, and where your competitors, investors are. All of those factors will play into exactly which jurisdictions to file patent applications in. But I will say almost all clients we work with start with a US patent filing. So what can be patented in robotics? The short answer is both the hardware and the software. So on the hardware side, you can protect mechanical and hardware innovations For example, actuators, sensors, arms, grippers, the assembly of the various parts, the energy systems, all of these things alone or in combination can potentially be patented. In addition, methods of operating robotic systems and components, how you coordinate various drones and robotics can potentially be patented. And Mike mentioned design patents, right? So design patent is a really a popular type of patents, especially for robotics, where you may want to file patents on the look and feel of a hardware component. I worked with a lot of autonomous vehicle companies, and a lot of them take pride in how their product looks. And so that is an area where you can consider filing design patents. And then on the software side, you can also patent pretty much all innovative aspects. Some of you may have heard that software cannot be patented. That is categorically false. In fact, the majority of patents granted by the USPTO are software patents, right? There are unique challenges that you want to preempt when it comes to patenting this type of things, but they are absolutely patentable and can form a really critical part of your IP portfolio. So in terms of software, you can patent control algorithms, computer vision, sensor fusion technologies, adaptive learning. You can patent the stuff that user interacts with, for example, GUIs, voice gesture recognition. And then you can also patent some combination of the various things that I mentioned, including any interaction or orchestration between the hardware and the software. Another question that I get asked a lot is what can be patented in AI, right? And so I like to think that there are two buckets of AI technologies. The first bucket is application of known AI to specific fields and sectors. So in this bucket, the inventor hasn't necessarily invented a brand new machine learning model or brand new machine learning techniques. But what they've done is they took something that is potentially off the shelf or open source, and then they tweaked it to solve a unique problem in a unique way, right? Whether it's in computer vision, robotics control, autonomous driving, even drug discovery or diagnostics, right? So this bucket of technologies is actually a higher value in terms of patenting because we can actually draft some pretty broad and detectable claims for this type of technology. And this is where most of the patent applications that we draft and prosecute are in. The second bucket is brand new AI models and algorithms. And kind of unintuitively, these type of things can actually be harder to patent because, as I will talk about, there are certain things that is by law not eligible for patent protection, and mathematics is one of those things. And so if you are really drafting a claim that is really low level and is about how a brand new machine learning model operates, sometimes it can really look like math. And so those kind of claims can be really hard to get through at the US Patent Office. And also potentially those kind of claims are really under the hood. And so it's really hard to tell if your competitors are actually practicing the same thing and infringing the patent. Okay, so very quickly in terms of where patentable innovations can occur for AI, here is a really simplified pipeline for developing AI models, right? So to your left, you start with an untrained model, which could be a neural network model. You set up what the input is, what the output is, and the various layers and things like that. And then in the second stage, you train the model, right? Using pre-structured training data and potentially using some unique training techniques. And then you end up with a trained model that has a great capability. And then in the inference stage, you can provide some new data for the trained machine learning model to process, right? And so in this pipeline, basically, any stage of this pipeline can potentially be patented. So starting from the first stage, the choice and the configuration of the model, to the extent that it's novel and nobody has configured the model, has chosen and configured the model in a particular way, that can be novel and patentable. In the training stage, how you structure and pre-process the training data can potentially be patentable. And this is actually where a lot of people are filing patent applications in because a lot of people have data problems, right? The data is too messy, or they have too much or not enough data. So a lot of the struggle with getting your machine learning model to work is really coming up with clean training data. And so that's stuff that can be patented. And lastly, once you have the trained model, you're feeding input and generating output. That method can be patentable, and also, outputs of the model. So this is kind of a narrow case where if you have like a drug discovery AI model, right? The output of the model, which could be novel chemical compound, those things can be patented in and of themselves. I will skip this slide. Okay, so patentability hurdles. So Mike mentioned these hurdles that you would have to overcome, or a patent application has to overcome in order to get an allowance. And I want to just take a step back and first say that even though these are the hurdles you potentially have to overcome, we overcome these hurdles all the time, right? So it's literally my job to talk to examiners and overcome these hurdles if they do come up. And so, in fact, for the vast majority of patent applications out there, they're going to get rejections at the patent office. And when that happens, we'll just talk to the patent examiner and figure out how best to overcome these hurdles. So the first hurdle is patent eligibility. So this is sort of a weird concept, and it's basically the idea that and I talked about this a little earlier, that under US law, there are certain things that are just not eligible for patent protection. Forget about how valuable it is, forget about how novel it is, it just by what it is, it cannot be eligible for patent protection. So things like natural phenomenon is not patentable, so you can't patent like the sun or the moon, which makes sense. Things like abstract ideas or mathematical formulas also cannot be patentable. Then that can be relevant for software, which we'll talk about later. Novelty and non-obviousness. So, but essentially, we have to show that what we're claiming is different from other patents or publications or products that are already out there. And also, it would not have been obvious for somebody to just take various known components and combine them. And then the last hurdle is written description. And this one really kind of is about the quality of the patent application. The actual application needs to describe the claim invention adequately. And that is, kind of the patent attorney's job, but also something that the patent attorney works with the inventors to make sure that the final written product is adequate. So let's first quickly talk about novelty and non-obviousness. So here are some wrong ways to think about an invention, and sometimes I get that from inventors, right? They say, oh, this invention just uses off-the-shelf parts. I didn't manufacture or design any new parts. Or I took this paper and I used some of the techniques mentioned in this paper, and I did some improvement upon it and came up with this, but it really all starts with a paper. Or I took some open source software, and that's what my platform is built on. All of those things may be true, but you can still get a patent, right? Because you improved upon it. And it's not really helpful to tell your patent attorney, oh, this is the foundation. This thing that already exists out there is the foundation of my invention. So the right way to think about your invention instead is thinking about, did I come up with a novel way to leverage existing technology to solve a new problem? And when I get these, off-the-shelf parts, when I have this paper, and I try to apply them, what are the technical challenges that I encountered and had to overcome? And how did I overcome those challenges? That is the story we want to tell in the patent application and to the patent examiners. So, as I mentioned before, eligibility is one of the hurdles. And I will just say that, first of all, it is just generally not a concern for hardware-related inventions, right? Because if you have like a piece of robotics component or hardware, it's not natural phenomenon, it's not math, it's not abstract. So you just don't need to worry about that, right? For software, it's a bit more of a gray area in that the standard is abstract ideas without significantly more are not patentable. And I'm not going to spend a ton of time on this because I can talk about this for a day, but essentially, you want to make your claims to not look like math. You want to make sure your claim doesn't look like you're just practicing some methods of organizing human activity, like fundamental economic practices or commercial or legal interactions, and just putting them on a generic purpose computer. You also don't want to make your claim look like it can be done just in somebody's head or using pen and paper, because those things would potentially be red flags. But I would say for most software that are deployed on robotics, right? And a lot of software that have graphical user interfaces and have, foundational AI models, it's really easy to overcome, these issues. So just to give you an example of what the USPTO has said is, a classic example of what is patentable is this method of training a neural network. And you see the last limitation in this claim recites training the neural network, right? And so the patent office said this claim is patentable because ultimately it's directed to training a machine learning model which does not involve mathematical concepts, at least in terms of, how there's no math formulas recited in the claim. These cannot be performed in the human head because you can't train a machine learning model in your head. And they're not, fundamental economic practices or other methods of organizing human activities. So this is something that can be patented. And while we're on this topic, I just want to mention that we have a new USPTO director who was sworn in just a month ago. And he has actually, since he took over, has taken a lot of pretty drastic steps, but he's provided some very, very clear signaling that he is pro AI and software patents. So he issued 2 patents as his first patents, which generally tend to be very symbolic of his stance on innovation. And one of the patents is a cryptocurrency related patent, right? So it really clearly signals that he's going to be probably going to be pretty pro software patents. In fact, in this decision that he wrote and issued recently, he actually made some pretty clear statements on his stance on AI. This is where the Patent Trial Board rejected a AI related patent application for being directed to abstract ideas, which we just talked about. And he reversed that decision. And he said that categorically excluding AI innovations from patent protection in the United States jeopardizes America's leadership in this critical emerging technology, right? So this is, just some additional information for your consideration. Okay, and then I'll just really quickly talk about written description and enablement. As I mentioned before, this is really about the quality of the patent application. And the patent application needs to show possession of the invention. And legally, it needs to enable a person of ordinary skill in the art to make the invention after they read the application, right? So that sounds like it can potentially be a high bar, but in practice, for software-based inventions, the requirement for data disclosure is not that stringent, meaning that you don't need to submit your source code. You don't even need to submit anything like that look like a pseudocode. What the examiners are really looking for is like claim charts. And so it shouldn't be super high level claim charts, but really they're just looking for claim chart that outline the key steps and the input and output of each step and how you go from the input to the output. And so you really don't need to submit all that much in a software-based patent application. And for machine learning inventions, you don't need to submit training data or validation data. Although some data on the performance of the machine learning model is always helpful. Okay, so these are my last couple of slides, and I want to just quickly talk about preparing disclosure materials for AI or software or robotics inventions, right? So if you do have a invention and you are planning to talk to your investors, you're planning to publish it, but you think that it's going to be core to your business and your technology, you should definitely talk to a patent attorney to decide, whether it's worth it to file a patent application on. And in order to get a patent application going, you would need to prepare some materials for the patent attorney, right? And it's important to keep in mind in that effort that patent application needs to really teach the invention. So you really want to tell a story about what the state of the art is, how bad or inadequate the state of the art is, and how your invention solves technical problems with the state of the art. So in that sense, you also don't want to kind of describe a magic black box, right? You don't want to say this is just a robot that can, achieve these tasks in a very efficient way. You can't just say this is a model that would make these magical predictions without really kind of opening up the black box, right? And showing how you are doing that. And then you'll also want to kind of describe with respect back to AI related inventions, kind of each of the stages that we talked about, and describe what is new or different with your approach.
Well, yes.
Is that a question? Okay, this is my last slide. So after that, we can open up for questions. As I mentioned before, for hardware and software patents, it's really important to have schematics, to have flowcharts, to have diagrams. It's very important to provide some concrete examples and explain the technical advantages. And also, this is something your patent attorney should tell you, but if they don't, you should really think about this in a strategic way, right? The purpose of filing the patent application is not to just cover what you have come up with, right? Because ultimately, this is a piece of important asset that is going to help you with fundraising and all sorts of things going forward. And so you want to think about what your competitors may be doing, right? Can I describe my technology broadly enough so that it's relevant to what they're doing? And also, if I have figured out one way to solve the problem, are there alternative ways, but some alternative but similar ways I can solve the problem? And you want to definitely mention those in the patent application. And lastly, it's important to think about what you may be doing in the near future to improve on your patent, on your invention, and mention those in the patent application. So you don't actually have to implement anything to describe it in a patent application, right? But you just need to provide enough detail so that somebody else theoretically can reproduce that invention. So if you have thought about some concrete ways you are going to be doing in the near future to improve your invention, those are the things you should potentially include in your patent application as well. So that is all I have. And now Mike and I are happy to answer any questions.
Anna, I can kick it off with a question. Can you explain to the students sort of the timing of filing a patent application and what do you have to worry about in terms of, you know, publications, describing your invention, those sorts of things where other people would know about it. Can you take the students through that, the timing?
Yeah, so effectively, before you're ready to talk about your invention, and this include discussion with investors, potentially going to conferences to give a talk, or publishing a paper, those are the critical time points that before which you want to consider filing a patent application. And the reason for that is if you don't file a patent application before, that public disclosure event, then that public disclosure event becomes prior art against your own patent application. So meaning that if you go to a talk today and you publicly disclose your invention, and tomorrow you file a patent application, theoretically, in a lot of really important jurisdictions like Europe and China, you can't because your talk or your paper is prior art against you, showing that your patent invention is no longer novel, right? As of the day you file the patent application. I want to mention that the US and some jurisdictions do have grace periods for this type of situations. So in the US, there's a 1 year grace period, but you don't want to rely on that because, as I mentioned, a lot of really important jurisdictions don't have that flexibility. And so that is like one critical juncture, public disclosure, where before which you want to have something on file. And then the other one that is really tricky that's very specific to US is the on sale bar. So the on sale bar is when you offer your invention for sale, right? So it's not even that you actually put it up for sale, right? It is when you offer something for sale that starts the clock, right? So that is the one aspect that sometimes can be really tricky to navigate because you may think, oh, I'm just talking to somebody about potentially selling my product, but I did not tell this person anything about how the invention works, or anything like that. So it's not a public disclosure. Sure, it's not a public disclosure, but it still starts the clock nevertheless because you've offered it for sale. So I would say those are the two key points where you want to consider filing the application before.
So Anna, I have a question for you.
Sure.
So I'm an instructor, I'm a faculty. So let's say I've developed a couple of software tools but I actually tested it with my students. Will that still be applicable for patent filing?
So so the question is you are working with some students and you came up with the invention together?
No, it's like my research group developed some software
Right.
tools, but I tested it as part of the lab activity to see the feel of it from my students in which I'm teaching class. Will that
Yeah.
still be applicable or it is not eligible because only the tool has been used to test out from the lab activities from students that I teach?
Oh, I see. That's a great question. So it's going to depend, but it really sounds like potentially you're fine. So experimental use is one aspect where you can still kind of practice the invention, but for the purpose of experimental use, for the purpose of improving it and testing it, and that doesn't count against you as prior art.
I
Thank
was
you.
just looking at the experimental use law yesterday for a client, and one of the most important aspects of it is that you as the inventor need to maintain control. So if you were to give your stuff to somebody else without any, you know, requirements for them to keep it secret or anything else like that, then it's no longer experimental use. It can be known as what is known as public use, which again is like this 1 year bar for on sale bar that Anna was talking about. Anna, we have a question from Pedro in the chat. He says, I see there's a trade-off between breadth and eligibility. If a claim is too broad, it can be considered generic. Is it possible to include multiple claims in the same patent application, some broader and some more specific?
Yeah, that's a great question. So yes, and we do this for every patent application. So the broadest claim is what we call a independent claim, and that's claim one. And right, and then we have a lot of dependent claim that says I'm claiming what is in claim one plus something in addition, right? So for example, in claim one, I can recite a chair, right? That just has a sitting surface and a bunch of legs. That is my broadest claim to cover a chair. And then you can have a dependent claim that says that chair that I recited in claim one, plus it's made of wood, right? And then you can have another one that says that chair that I recited in claim one, plus it's, this high. So that is a really great tool that we use for every patent application to provide backup positions. And a patent examiner has to examine every single claim. And so there are circumstances that where the examiner thinks the independent claim is alone is not novel, right? Because there's prior art, but they couldn't identify prior art for some dependent claims. So they would just indicate these claims to be allowable.
The other reason why you want to have multiple claims is in an infringement situation. So if you were to sue somebody for patent infringement based on your patent and you had, say, 10 claims, all of which started from the broad claim, like Anna was talking about, in one down to 10, where it was very narrow, and 10 still covered the product. And you sue the person and they raise a defense, oh, this stuff is old. We found this in the prior art before. And they're able to find and knock out claims 1 through 9, but they can't knock out 10 because they can't find prior art that discloses 10. And 10 has all the elements in that you really care about and all the elements that the infringer is using. That claim will survive the litigation. And you'll end up with one claim, but that's all that may matter at the end of the day. So having all these fallback positions is really, really important because when a claim gets challenged or when a patent gets challenged in litigation, it's a claim by claim analysis. So it's important to have those backup positions. So Pedro, that was a great, great question.
It's a great question.
Are there any other questions? I want to just
I
remind,
can pose one from the competition actually,
yeah.
and listening to this and about public disclosure of information.
Mhm.
We ask the teams to submit a 5-minute video and a written report that can be judged, and then that's how we distribute the awards. Is there anything that we should guide the teams to maybe exclude from those materials to protect them?
We don't want to obviously chill the competition. You don't want your patent lawyers come in and
Yeah.
say, no, no, you can't talk about it. I think it's important um, to if you've got something that's really, really unique that you're and it's meaning you're able to display it and people are going to say, ah, I get it. I see what you've done. You put A, B, C together. If people can see it, you should really be talking to your licensing office about the possibility of filing a patent application before you go forward. But if it's something that you can't see, it's buried within the software or whatnot. Anna, do you
Okay.
agree on that?
Yeah, absolutely. And also another factor to consider is what's going to happen to these submissions and report, right? If they're going to be put on YouTube, right? So that is a really clear public disclosure, and that is a triggering event that we'll need to uh work around. But there are, to the extent that it just gets submitted to a committee and the, committee reviews it and the material is restricted to the from the public, then there are arguments that it is not accessible to the public, right? And there's actually a lot of case law about what is considered to be accessible. If you have an article that is hidden in one library in the world, and the article is not indexed, in that case, that article, even though anybody can technically go there and read it, is not actually considered a public disclosure, right? So there's a lot of case law around what public disclosure means. And I would just say another thing to consider is like, what after you submit the materials, what's going to happen to the materials, and to the extent that the materials will be kept relatively confidential, you definitely don't want to, after submitting it, like putting it on on YouTube, if that's something you want to potentially patent.
Yeah.
Well, that's really good to know because we do post the videos on our website.
Okay,
And
yeah,
maybe we need to have opt-in to that. But any written materials are kept confidential, and yeah,
that's
we don't
great.
distribute those at
That's
all.
good.
Yeah.
Right.
Yeah.
So,
Okay.
Anna, Dave has asked, what protections does a provisional patent application give a holder? Are there caveats to
Mhm.
the patent pending that an inventor should be aware of?
Yeah, that's a great question. So to your first question, what protections does a provisional patent gives a holder, right? So a provisional patent application, um, as Mike mentioned, this is sort of a placeholder application you file with the patent office. You
Mhm.
file it to get that timestamp for your technology, right? So if you file it today, theoretically, if the application is really robust, you get the timestamp, the early timestamp for your invention.
Yeah.
But the great thing about provisional patent application is the patent office doesn't examine it right away. You have to convert it into a non-provisional, for the patent examiner to pick it up. And you have a year to do that. And that's great because you can file it. And then in a year, you can decide whether you actually want to pursue patent protection with it, or and also even if you do, whether you want to add something in addition before a patent examiner picks it up, right? So a provisional patent application is very, very common, especially for early stage companies. It's also a great way to defer cost, right? So in terms of protection, I would say, you can tell your investor that you have patent pending, right? You have something on file that covers your technology. It, however, doesn't give you the right to assert the patent. No, no patent applications can be asserted against, anybody for patent infringement. You actually have to, get a granted patent to sue somebody with, right? So a provisional patent application or any patent application that has not been granted for that matter, does not give you the right to assert the patent. Um, and then I hope that answers the question, but happy to,
It it does a bit. Yeah, I think you got it. So thank you.
yeah.
So I'll add one thing to what, or highlight one word that Anna used, which I think is really important here, and that is robust. She says the provisional needs to be robust. And what that means is if you simply take your slides, for instance, a PowerPoint, we've heard the word, we do not file these. We've heard the word in the industry that certain patent attorneys will file what are known as cover sheet provisional patent applications. They literally take the PowerPoint presentation or the slides that are going to go into a poster. they put a cover sheet on it and send it into the patent office. The problem with that type of filing is that they rarely, if ever, have any claims, and they really often don't get to what the invention actually is. And so, as that provisional patent application, it may sit there and you file a follow-up patent application, which claims priority back to that provisional. You may wait until the year deadline to do that. You may get into a battle as to whether or not that first provisional patent application actually enables, that is, supports the claims in the filed application that comes a year later. If it does not enable those, you lose that priority date. So that cover sheet provisional application that you're filing in order so that you can go and give this public disclosure and put it on YouTube and everything else, that YouTube disclosure will completely prohibit you from getting a patent application, and that provisional patent application will not help you because it isn't enabled. It's just a cover sheet. It doesn't describe, it doesn't claim what it is. So you need to write a robust patent application that actually has claims where you have these fallback positions like we're talking about. It needs to look like a real patent application, but it's filed as a provisional because the costs are less at the patent office, and it gives you a year to perfect and develop the invention even more and file those changes in the full utility. So don't get caught up in saving a lot of costs by filing this provisional because that thing may not do you any good at all.
Yeah, and I just want to put some context, to me, a lot of it really goes back to fundraising. And we represent a lot of investors that, are vetting startups. And, a lot of these startups have only provisionals, which is totally fine. But, we really need to look at the quality of the provisional application. If we see a two-page, right, or a PowerPoint as a provisional patent application, I wouldn't say it's it's like worse than not filing anything, but it's close. Right? It just leaves a really bad taste in the investor's mouth, and it just shows that the company is not ready for prime time, right? So that is a big concern. The second concern, like Mike mentioned, is, ultimately what is the value of that provisional application, right? So if you ever assert the patent against your competitor, and again, we also do a lot of defense in the IP litigation context, where our client gets sued, right, for patent infringement. One of the first things we look at in terms to determine the priority date is to look at the quality of the provisional application. If it's a two-pager, if it's like a poster, we just that's a huge red flag, right? Like that's something we can like kill the patent. Yeah, like it opens up more prior art for us to invalidate the patent with. Again, I think it just comes down to what are you getting out of a cover sheet provisional, and it's I would say nothing.
I see. Well, looking back at you scared me for a second. I looked back at my provisional. It's 5 pages with the diagrams and schematics on it. So I don't know if that's warranted. But man, that scared me there for a moment real bad.
Dave, is it still within the year?
Yes. Yes,
Yeah.
it is.
So you're fine. Yeah, you can fix it.
Sorry, you just made me. Oh no! Wait, how long is it? It's 3 pages of content and then 2 pages of schematics. But I would love an extra set of eyes, but I understand everyone's time is valuable, so I don't know how best to approach it.
But Dave, that's precisely the sort of thing. We offer a half hour of free advice, and we'd be happy to do. We do that on a confidential basis that we don't charge for. So, reach out by email, and we'd be happy to help there.
I'll absolutely take you up on that offer. So thank you. I appreciate it.
For all the participants today, if there are something that you want to talk confidentially about, we're happy to answer those questions. Are there any other questions from the group? Okay. Well, thank you all for being so attentive. It was great to have an opportunity to talk to you about intellectual property, and please reach out to Kelly. If you'd like to contact us, we're happy to. You can find us on the web as well at mofo.com, but we're happy to talk at any time.
Well, I really appreciate Mike, you and Anna doing this webinar. Um, it's a subject area that, yeah, we need experts to lean on. So really appreciate, yeah, your advice and guidance. And this is exciting for the program, to be able to offer this and support teams that want to go down that road of taking things to the next level, potentially commercializing and incorporating into a business. So yeah, thank you again on behalf of the competition for being a really great partner this year.
You're welcome. You're welcome. It's our pleasure.
Thank you.
Bye-bye, everybody.
All
Bye.
right. Thank you, everyone, for joining.